Madam Chief Justice, and may it please the Court, Scott Flaherty with the law firm of Briggs & Morgan, representing appellant Marcia Stressman, doing business as Affiliated Counseling Center, or ACC. This appeal presents the issue of whether prosecutorial immunity should be extended to an investigator who loses or destroys property seized under a search warrant. A resolution of this appeal requires nothing more than a straightforward application of this Court's decision in Brown v. Dayton-Hudson.
The one thing I want to be clear about before we get too far into this is the only issue that's before us is the question of absolute immunity. Is that right?
That is correct, and specifically the form of absolute immunity known as prosecutorial immunity. That is correct. That was the only question raised in the petition for review that this Court granted, and that was one of the issues decided by the Court of Appeals and the District Court.
Counsel, could you briefly recount for me, and I didn't see this in the briefs, which is why I'm wondering about it, what the history of judicial/prosecutorial immunity is, and in particular, whether it started out as a really narrow doctrine and it has expanded, or whether it was always sort of as expansive as we have articulated it, or sort of what is the historical origins of the doctrine?
So, traces of prosecutorial immunity can be found in this Court's case law before Brown v. Dayton-Hudson, but Brown declared itself, not unreasonably, a case of first impression regarding prosecutorial immunity. It adopted and applied the U.S. Supreme Court's precedent in Imbler, and Imbler walked through in detail the historical basis for prosecutorial immunity for public prosecutors. It had a basis not only in the common law of the United States, but also going back to England. And so this Court's view in Brown appears to have adopted that historical analysis, but it didn't regurgitate it itself. It simply cited to Imbler. And this Court has discussed Brown since that case, but it hasn't squarely applied prosecutorial immunity as a doctrine in its cases. So in our view, the accurate statement of Minnesota case law as it extends, as it applies to prosecutorial immunity today is that Brown is the law, and the test articulated in Brown determines whether or not any defendant is entitled to prosecutorial immunity. Any defendant whose liability turns on the initiation or maintenance of criminal charges is entitled to prosecutorial immunity.
And your view is that Brown represents, because it relied on Imbler, that that's an accurate sort of statement about the bounds, both historically and modern view of what prosecutorial immunity should cover.
That's correct. And in fact, in relation to Imbler, the Brown decision used the word adopt. I forget if it was adopted or adopts. It was a little unclear whether that adoption was directly from Imbler or from the litany of other state court cases that had adopted that view of prosecutorial immunity. But some view of the core of Imbler has become part of Minnesota case law. And so the historical view in Imbler is also, I think, fairly characterized as part of this Court's state law. Now, in the subsequent to Brown, the U.S. Supreme Court has spoken again, and there's been what can be characterized as an evolving dialogue in the Court regarding what the history actually shows and how that might shape the contours of prosecutorial immunity. And of course, to the extent that question is open under federal law, it is also must be open under state law because this Court hasn't spoken to that issue. We don't view the resolution of those historical questions as necessary for the Court's decision here today, because all we're asking for is a straightforward application of Brown to these facts. That application is in fact what the District Court did when it concluded that Morton Peters did not have prosecutorial immunity. In contrast, the Court of Appeals did not apply Brown. It instead applied its own cases, which articulate a test different than Brown, to conclude that prosecutorial immunity should be given to Morton Peters here. So we're asking nothing more, essentially, as we put in our brief, for this Court to reaffirm that Brown is the law and to apply it here to these facts.
And where does the Court of Appeals go astray in its analysis? Just articulate that for us when I look at the history of the Court of Appeals cases, not just the case that we're reviewing.
So there are two responses to that question, Your Honor. The first is the Court of Appeals' first deviation. I think it makes sense to ask why that occurred. That was in the 1984 decision in Berry, where a pro se appellant was challenging the denial of his claims. Berry, by its own terms, they used the word extended Brown to investigators. So in the Court of Appeals' view in Berry, Brown left unanswered the question of who else may have prosecutorial immunity besides prosecutors. And then that question, the question of who, of identity of defendants, you saw that then again in Highland, which talked about if a defendant's employer has statutory authority to investigate and prosecute crimes, then that employee also has immunity. The mistake made in Berry and repeated in Highland, and to a lesser extent in the Brotzler case from 1988 and Erickson in 1990, in all of those cases, the Court of Appeals was misunderstanding this court's expression of immunity under Minnesota case law. Immunity protects certain conduct. It doesn't protect certain job titles. So the Court of Appeals was wrong, but it wasn't unreasonable to focus on the who. But this court's decision to make clear that immunity protects conduct, not people. And so instead of asking the question what conduct was challenged in Berry or Highland, the Court of Appeals asked, who are these defendants? Do they work for employers who have statutory authority, or do they work in a prosecutor's office? By asking that who question, that's why they got the wrong answer. The question under this court's immunity case law is what conduct is challenged. If that conduct, regardless of the who performing it, if that conduct falls within a test for immunity, that conduct is protected. So conduct is what is protected, not individuals, not job titles. And that's where the Court of Appeals went astray. And the Court of Appeals wasn't alone in this. In the cases between the U.S. Supreme Court's decision in Imbler and its later decisions in Byrne, Buckley, and Hartman, some of the federal courts of appeal made the identical mistake under federal law and confusing the question of what conduct is challenged with the question of who is performing the challenged conduct. And so that's the distinction, is that immunity is designed to protect certain conduct, not certain job titles or certain peoples. And so that's where the Court of Appeals went astray as a substantive matter. And then as we point out in our brief, as a doctrinal matter specific to Minnesota State Court case law, there are cases suggesting that it is improper for the Court of Appeals to extend the law when this court has not done so. And, of course, by its own terms in Berry, the Court of Appeals chose to extend the Minnesota common law. And so those are essentially the two mistakes the Court of Appeals made, extending the law that had been articulated by this court and then viewing Brown as a question of who rather than what conduct. As long as the focus is on what, then the application of Brown to any fact is straightforward. You look at the plaintiff's complaint, and if the defendant's liability turns upon that initiation or maintenance of prosecution, the conduct is protected. If the plaintiff's claim does not turn on the initiation or maintenance of prosecution, then prosecutorial immunity is not present, and a district court can consider what other immunities may be available.
Counsel, with regards to the complaint that you mentioned, I took a look at the complaint, and it alleges at paragraph 4 that Ms. Morton Peters is, upon information and belief, employed by the Medicaid Fraud Control Unit of the Minnesota Attorney General's office. Is that an allegation that she is, in fact, a member of the Attorney General's office, or is she on detail from DHS? What does the record tell us in that regard?
So the allegation there is simply her residency for the purpose of identifying the parties and that she's an employee of the office. It is not an allegation that she is an attorney or that she makes decisions regarding the initiation.
Well, I realize all employees get their checks from the state of Minnesota, but is she an employee within the Attorney General's office, or is she an employee within DHS, and does the record tell us that and who her supervisor is?
If I'm recalling correctly, I don't believe the record tells us who her supervisor is, and because this is an appeal from a Rule 12 motion, the facts in the complaint are alleged as true. The other allegations about...
Although there's an affidavit from John Degnan, if I recall, with some factual material.
And if, by my memory, I think at the time the complaint was filed and the document, the Degnan affidavit, as well as the allegations in the complaint, candidly, I think it was unclear exactly where she was stationed within the broader organizational structure of the Attorney General. Does
that make a difference? There's been a debate about whether prosecution offices should be employing investigators. It strikes me that it might well be one thing that if she's an investigator in the Department of Human Services and is just assigned or detailed to the Medicaid Fraud Control Unit within the Attorney General's office, then she's like a Minneapolis cop assigned to some kind of task force. On the other hand, if she's an employee of the Attorney General's office, doesn't the state then have a stronger case that she's really acting as an arm of the prosecutor under the direction of the prosecutor and would have a better claim to absolute immunity?
To the answer to the first part of that question, yes. To the answer to the second part of the question, no. So the first part of the question addresses is if she is within the heart of some prosecutorial organ within the Attorney General's office, isn't her claim to be acting under the direction of a prosecutor, isn't that a stronger claim? The answer to that is yes. The more closely she works with the prosecutor, the easier it is for her to claim that she's acting under a prosecutor's direction or control, for example. But that fact is not enough to trigger prosecutorial immunity, because prosecutorial immunity, both under this Court's decision in Brown and federal case law, doesn't ask how closely with a prosecutor is someone working. That's not the question. The question is this person responsible for initiating or maintaining criminal charges? So, for example, let's suppose, hypothetically, that within the Attorney General's office, it employs only prosecutors, and the prosecutors have to do all of their own internal investigation, and then the advocacy and initiation piece. Under Brown and under federal court case law, those prosecutors would not have immunity for their investigative functions. So the focus of the immunity inquiry is not how much like a prosecutor does this defendant look or how closely does this defendant work with a prosecutor. The question immunity asks is this person, is plaintiff attempting to hold this person liable for acts involving the initiation or maintenance of prosecution? It's not how much like a prosecutor does this defendant look. That would be a very different question.
Counsel, let me ask you a related question. Suppose you have similar facts, but you have a prosecutor, and this is tied up with the service of or the execution of a search warrant, which looks a lot like what gets prosecutorial immunity. At least obtaining that particular search warrant, you would think would be prosecutorially immune. But suppose in collecting the documents, the prosecutor loses some of the documents. In other words, he or she was reviewing the documents in order to prosecute the case and can't find them anywhere. Perhaps they were shredded. I don't know. Prosecutorial immunity there or no prosecutorial immunity?
So under Brown, no, because Brown asks the question, is the liability of the prosecutor based upon the initiation or maintenance of prosecution? And unless the prosecutor has some clever defense about how this destruction or loss was necessary to maintain or continue prosecution, there wouldn't be prosecutorial immunity. Now, with the prosecutor example, I think we have to consider an issue outside the scope of this appeal, which is whether some form of quasi-judicial immunity protects any officer of the court who destroys documents or loses property that is part of the filing or service with the court. I think that is a separate question, and the answer to that is maybe. Maybe there is some form of immunity that would historically be recognized or that this court can later choose to create.
I mean, the point doesn't the doctrine, at least, I'm rereading Imbler, have to be a little bit more malleable than you make it out to be, in the sense that, while looking over these documents is not an essential characteristic of filing an action or presenting an action to the court, I mean, it is a pretty integral part of being able to prosecute a particular claim. And so shouldn't it be a little more malleable to take into account those things that are sort of closely related to maintaining an action, to give the prosecutor a little room to breathe, so to speak?
As a historical matter, two responses, one historical and then one doctrinal. As a historical matter, I think no. In none of the cases cited in Imbler or any of the historical cases was there a suggestion that immunity for destruction of property, including by a prosecutor, was subject to prosecutorial immunity. Again, whether other kinds of immunity are involved is a separate question. So that's the historical answer. And then there's a doctrinal concern, which is that in this Court's immunity case law, both in Brown and in other forms of immunity, quasi-judicial immunity, discretion is somehow involved. And the parties may disagree here as to what role discretion plays in this form of immunity, but a prosecutor doesn't have discretion to destroy documents. And that's the difference. And I can't think of an unusual case where that discretion might exist, but I also can't rule out that existence. But that's what distinguishes the example of anyone destroying documents. And in fact, as to property seized under a search warrant, the Minnesota legislature has spoken on that at least twice. Section 62604 requires that property seized shall be safely kept. Shall is mandatory. And then again in 629.361, The legislature requires that an officer who seizes property shall be answerable for it.
Counsel, the last time I think we spoke on absolute immunity was in Zutz versus Nelson, which is a libel case. I realize it's not directly on point here, but it's a slander case, I guess, actually, arising out of proceedings before a watershed district. Does that case have any bearing on this case, on the disposition of this matter?
It doesn't, Your Honor, and those defamation cases are, they do speak about something that looks like absolute immunity, but a careful read of that case, as well as this Court's decision in the Jessen case from, I believe, 1966, those are really about the testimonial privilege, which is absolute, but it's not about immunity, it's about a privilege, and there is a subtle distinction there.
So I'd be interested in the rule of law that you would propose that we adopt in this case, and maybe the best way to ask the question is, does an investigator who participates in the decision with the prosecuting attorney as to whether or not to initiate a case and participates with the prosecutor in the trial of the case in terms of gathering documents and working like a paralegal, I guess, would absolute immunity extend to that person for the destruction of documents arising out of those two circumstances?
And my answer to, I understand there may be two questions there, the response to the latter one, and then what are we asking this Court to hold today? Yep. And so I'll deal with those in reverse order. The answer to the second question is similar to what I stated to Justice Strauss, which is prosecutorial immunity would not extend to those acts, but it's an open question under Minnesota case law as to whether or not some other form of immunity would protect them. And then as far as the holding we asked to be applied here, this Court can fairly recognize that the Court of Appeals viewed Brown as leaving open the question of what other persons are entitled to prosecutorial immunity. And the holding we want this Court to announce in this case is that any defendant whose liability turns on the initiation or maintenance of criminal charges is entitled to prosecutorial immunity. And if a defendant's liability does not turn on either of those things, then they are not entitled to prosecutorial immunity.
Counsel, what are we to do with the language from Imbler which suggests that in order to be entitled to absolute immunity, that the conduct must be, or the activities must be intimately associated with the judicial phase of the criminal process?
So that language in Imbler was implied and was later held by the Supreme Court to rule out non-judicial prosecutorial acts from the scope of prosecutorial immunity. And so that recognition, which is strong in Imbler and is highlighted less in Brown, is that part of the reason prosecutorial immunity exists as a form of absolute immunity is to protect the judicial process. Prosecutorial immunity is a judge-made doctrine, and it exists in large part to protect the judicial functioning. And so that's where that language in Imbler comes from, because it recognizes that prosecutors, the job of a prosecutor is not solely judicial. They sometimes engage in investigative functions. County attorneys can, of course, act as HR managers and hire and fire people. I don't think there's any suggestion that if a county attorney fired an employee based on race or sex, that would be immunized simply because a prosecutor had engaged in that sort of...
Well, counsel, let me follow up on that. Minnesota law gives the Attorney General a great deal of power to investigate, and in fact, in Section 8.31, it gives the Attorney General the power to issue civil investigative demands and gather documents on a wide variety of subjects. In your view, does the rule that you're arguing today mean that the Attorney General, in issuing a civil investigative demand, is performing a prosecutorial function, or is she performing an investigative function?
So a civil investigative demand is at least linguistically investigative, but also as a prosecutorial matter, it's also not necessarily criminal because it's civil. And so that I can't imagine any situation where a civil investigative demand would entitle the Attorney General to prosecutorial immunity. Now, the Attorney General would...
So your argument is prosecutorial immunity is limited to the criminal context?
The initiation and maintenance of criminal charges, that is correct. That's the heart of the prosecutorial function. Whether there are other Quasi-judicial immunities for civil investigative functions, that's a different question.
At the time of the conduct here, had criminal proceedings been initiated?
No, Your Honor.
May I have a moment to ask one more question?
Yes.
The federal statute dealing with state Medicaid fraud control units seems to express a preference for having auditors and investigators in the state attorney general's office for the purpose of prosecuting Medicaid fraud. Is that relevant to where we draw the line as to whether an employee in the attorney general's office does or does not have absolute prosecutorial immunity?
Not under Brown, Your Honor, because the test doesn't ask where do they work. It asks what is plaintiff's claim based on. That's the question, Brown, not where do they work.
Thank you, counsel. You have 15 minutes for rebuttal. Mr. Ikeda.
May it please the Court, my name is Scott Ikeda. I'm an Assistant Attorney General at the Minnesota Attorney General's Office, and I represent the remaining defendant in the case, Kate Morton Peters, who's a former investigator in the Medicaid Fraud Control Unit in the Minnesota Attorney General's Office.
And counsel, as you described her as a former investigator in the unit, for whom was she working? Was she working for the Attorney General's office with a supervisor in the AG's office, or was she detailed from DHS? And does the record tell us that?
Your Honor, if you look at the Court of Appeals decision, it indicates that she is the chief investigator at the Medicaid Fraud Control Unit, which is in the Attorney General's office. And I can, as an employee of the Attorney General's office, I can represent to the Court that Ms. Morton Peters was, in fact, an investigator employed by the office. She's not a DHS employee.
So reporting to an Assistant Attorney General?
Correct. Correct. So this case is not as simple as the adoption of federal prosecutorial immunity law. In Brown, when this Court discussed Imbler, it did not, I think, as the appellant suggests, clearly adopt federal law. And it didn't do so because of a couple of reasons. The first is, as this Court knows, this claim, or these two remaining counts, are purely state law claims. The 1983 claim, on which prosecutorial immunity has developed, is no longer a part of this case. The appellant never petitioned for review of that issue. So the only issue before this Court is what type of immunity is someone like my client entitled to under state sovereign principles for a state common law tort claim. And it can't possibly be as simple as the appellant suggests, where you adopt federal law. And we know that because of the Elwood case, which explicitly holds, this Court explicitly holds, that the defense of qualified immunity, which is otherwise a defense in a 1983 claim, is not applicable to state tort law claims. And so essentially what the plaintiff would be suggesting, I think, is that by adopting federal law and by purely adopting federal law and prosecutorial immunity, that somehow Elwood would be reversed and my client would then be entitled to the defense of qualified immunity in this case.
So if
yes.
you were to extend absolute immunity here in this context, would it not necessarily follow that all police officers, when they're investigating potential crime, would have absolute immunity?
No, not necessarily, Your Honor. The unique function of the investigator, as Justice Lillehog pointed out, the statute sort of delineates at least the role of the Medicaid fraud unit within the Minnesota Attorney General's office, both federal and state law. And it's really, if you look at the development of prosecutorial immunity law, it really looks at sort of protecting the independence and the function of the prosecutor's office. And there really is no dispute that this unit within the Attorney General's office functions as a prosecutorial office. And so it would not, a ruling in my client's favor does not necessarily mean that absolute immunity is then applied to police officers, say, in a 1983 claim.
How would you distinguish it? How would you distinguish a police investigation from what happened here? Is it because there's a state statute? I mean, what is the distinguishing factor in terms of applying prosecutorial immunity?
So I think there are two and possibly three answers to that question. The first is as the record indicates, this warrant was not executed by my client. She does not function as a police officer in that sense. The Fridley Police Department separately executed the warrant. The second is that she is not a police officer or a licensed peace officer at all, and so you can draw that distinction. The third is that she is directly employed by the office who, by federal and state law, is charged with investigating and prosecuting Medicaid fraud. And going back to sort of one of the questions I think someone had about where may the Court of Appeals have gone wrong, what I think the Court of Appeals actually in the latest case, Highland, really did or assumed based on the statute correctly, I think, that when the statute says that your responsibility is to investigate and prosecute Medicaid fraud, then we take you at your word that you are functioning like a prosecutor in a prosecutor's office. And so I don't, respectfully, Madam Chief Justice, I don't believe that an adoption of a rule that allows my client to prevail before this court necessarily eviscerates the doctrines of qualified immunity and other immunities that this court has applied to police officers.
I guess the fact that we need to use two different words, investigate and prosecute, means that there is a distinction there, and that a person can have dual functions, and then we've got to figure out what were they doing at that time when the act occurred. But it seems to me you're conflating investigation and prosecution in a way that does away with any distinction whatsoever. Why should we endorse that?
Well, respectfully, Justice Wright, the case law itself bears out and I think Buckley actually says this, if the court were to adopt Buckley, and by the way, as the court knows, Buckley followed Imbler and was after Brown, and so there was no way that this court could have adopted a case that hadn't yet existed. But I believe it was Buckley that even said that the prosecutorial immunity would apply to investigatory acts that were part of the initiation and maintenance of a prosecution. And so that's sort of where the line gets possibly a little bit fuzzy, is at what point does something become for the initiation and maintenance of the prosecution, and at what point doesn't it? And as Justice Strauss pointed out, once you have the search warrant, once you go to court and make the application for the search warrant, it seems to invoke some kind of judicial process. And if you look at the history of this, of prosecutorial immunity, and actually, as a subset of quasi-judicial immunity, this court, at least since the 1800s, has taken a much broader view of quasi-judicial immunity than maybe the name suggests.
Now, so let me ask you this: if everything were the same, except that it was the police and not an investigator within the Attorney General's office, would the police be entitled to immunity, absolute immunity? Everything else being the same?
The police officer would, because they don't, the notion of prosecutorial immunity is founded upon the need to preserve the independence and regular functioning of a prosecutor's office. And those concerns, which this court and the U.S. Supreme Court have articulated as sort of a basis for prosecutorial immunity, are not present when evaluating the conduct of a police officer. So I would say that the interests are different. The police officer would likely be entitled.
But the conduct is the same.
That's correct. I concede that the conduct is the same, but the interests are different. The interests of preserving the independent functioning of the prosecutor's office and versus the police officer who would be entitled to official immunity. And if
Counsel, let me press you on official immunity, though, and this goes back to both Justice Page's and the Chief Justice's questions. I understand your responses to the police officer question. I understand the response you gave. But here's the problem. Your brief draws the distinction that I think swallows official immunity, which is you seem to premise your argument, at least in the brief, although it might be something different today, on discretion and exercising discretion. Well, the problem is that's exactly where official immunity draws its line. For ministerial duties, you can't do something under state law. We don't extend official immunity when that person does something that's prohibited by state law. And so I'm just trying to figure out where should we draw the line, because I'm not persuaded that we draw it at discretion, as you state in your brief.
Well, with respect to the question of discretion versus ministerial, and that sort of gets to the heart of what my client is being deprived of if the court doesn't take the broader view of prosecutorial immunity like it does in other quasi-judicial contexts. The issue of discretion, and I know the plaintiffs say that my client didn't actually exercise discretion, that there's no discretion when there's a statute that says property seized shall be safely kept. I think that the court's case law, by the way, bears out that the language of shall doesn't necessarily imply that it's a ministerial act and not a discretionary act per se. But with respect to the issue of if the court, if you don't, you're right that prosecutorial immunity, as we've articulated it, would likely give my client the benefit of that immunity even for a ministerial act. And if, in fact, the policy reason for that seems to make sense too, because if, as the plaintiff suggests, she's not entitled to official immunity, and if, as this court suggests, she's not entitled to qualified immunity as a defense under Elwood, then my client's really left with no kind of immunity defense for, and if you look at the amended complaint, it's very clear, for negligent, at most negligent conduct.
Well, let me ask you this. Why would we draw the line at the line drawn for official immunity, for prosecutorial immunity, rather than take the much more straightforward, which I think is supported by both our case law and the U.S. Supreme Court case law, of simply saying, is this what a prosecutor does? That, to me, seems like a much more sort of straightforward line than sort of encroaching upon the discretionary lines in official immunity. Why shouldn't we do as appellant suggests?
Well, first of all, I think even if you looked at it functionally, by statute, and granted this is on a motion to dismiss, so it's a very limited factual record for this court to consider. But even if you looked at it as a functional question, by statute, my client clearly performs a prosecutorial function because that's what the statute says she does.
And counsel, you're referring to the federal statute, or you're referring to 256B.12?
256B.12 talks about where the Attorney General's office, or the functioning of the Medicaid Fraud Control Unit.
And forgive me, Justice Strauss, for interrupting, but it seems to me that may be an important distinction, and may I follow up on that? 256B.12 says the Attorney General or the appropriate county attorney may prosecute these matters. But in your brief, you cite that for the proposition that the Attorney General's office has authority to prosecute and investigate Medicaid fraud. We're in 256B.12, or actually anywhere else in Minnesota statutes, is the Attorney General's office granted authority to investigate Medicaid fraud?
And I may have misspoken. I think you can find that in federal regulations. The issue of investigation, and we cite that in our brief.
Well, there's the federal statute, 42 U.S.C. 1396BQ.
Correct.
Yeah, that's that which establishes the idea that if you're going to get Medicaid, you have to have a state Medicaid fraud control unit, right?
Yes.
Okay.
So really, at the end of the day, the question before the court is an open one. As the Imbler court noted, and Imbler was the only Supreme Court case that was present when Brown was decided. As Imbler noted, it left open the question of how broadly to interpret prosecutorial immunity. And so even if this court were to say that Brown was somehow, or that Brown adopted Imbler, Imbler even left that question open. And so the question before the court is, well, do you adopt Buckley? Do you adopt Burns? And with respect to these claims, these are state common law tort claims against a state actor. This court has the final say about how broad to interpret prosecutorial immunity as to its claims. There will be no...
Are there any statutory immunity issues in this case?
There were...
Discretionary immunity, for example, under the state statute?
Your Honor, the defendants raised that at the district court. We did not appeal that issue, and so the only issues before the Court of Appeals was, and that issue, that immunity, by the way, was denied by the district court, and so the only two immunities appealed from, or the denial of immunity, was official and prosecutorial immunity.
So are you saying that if we don't extend prosecutorial immunity here, there will be no immunity? Or are there still issues to litigate about the applicability of some other common law immunity?
There are. I'm not suggesting that there's no immunity that she can claim. I'm suggesting that by the plaintiff's own statements and arguments against the application of official immunity, they're suggesting that because it's not that because my client's conduct doesn't meet the criteria for official immunity, she should be denied that immunity. And the point that I'm trying to make to this court is simply adopting federal law is not the answer, because you would undo cases that allow qualified immunity as a defense, or you would undo the case that says qualified immunity is not a defense to a state tort law claim. Whereas if we were in federal court and it was a 1983 claim, my client could, and in fact as to the 1983 claims, did claim qualified immunity successfully at the Court of Appeals as to the 1983 claim.
If we conclude that absolute immunity is not available in the context of prosecutorial immunity, that doesn't answer the official immunity question, does it?
No, Your Honor, and that's why I think both parties in their briefing to this court indicated that the relief here, if the court reverses the Court of Appeals, is a remand to the Court of Appeals for consideration of the official immunity claim that was on appeal and that the district court denied.
Counsel, let's change the facts of the case. Let's assume that instead of the Attorney General's office, it's the Anoka County Attorney's office that's interested in this matter. And it looks like under 256B.12, county attorneys can do this as well. So you've got an ex-cop working in the Anoka County Attorney's office who goes and performs a number of investigative acts, some of which may, on their face, violate Minnesota tort law. Does that investigator in the Anoka County Attorney's Office have absolute immunity?
I'm not sure that question would necessarily need to be answered by whatever decision the court announces today.
Well, we might not need to answer it if we're going to try to determine what the rule of law is. I would appreciate your thoughts on that question.
Well, I think that the same considerations would probably apply to that it is a prosecutor's office, and especially if the facts are the same, where you've already had a search warrant approved, signed off on, approved by a district court judge, and executed by the local police department. I would suggest that the outcome would be the same under those facts.
Same hypothetical, but the assistant Anoka County attorney is working with a cop in the Anoka Police Department. Does the cop then have absolute immunity?
Well, that's a different analysis, and those are different interests. And as the case,
all you've done is change the name of the employer in my hypothetical. Why does that make a difference?
Well, because if you look at the history of prosecutorial immunity has been premised upon this belief that it was necessary to protect the unique functions of prosecutors' offices that you don't have when you're in your hypothetical, you're inserting a police department who, if they were sued under 1983, would have the benefit of qualified immunity, or in the case of a state tort law.
The two investigators performing the same functions, just the name of the employer is different. One, the name of the employer is a prosecution office. Another name of the employer is the city.
Well, to be totally clear, I'm not conceding that the answer is no, but I'm suggesting that given the court's development, both the U.S. Supreme Court and this court's development of the law on prosecutorial immunity, it is premised upon the unique functions of a prosecutor's office. And so those are concerns that are just by their very nature not present with a police department. And so that's the answer that I would give to that question.
Well, one last question, if I might. What was the unique prosecutorial function that the employee of the Attorney General's office was performing in this case? What was she doing that someone employed by DHS as an investigator or by a Hennepin County investigator could not be doing? She was doing it because she was associated with a prosecution office.
That's right. That it is.
But what was she doing that was unique to being associated with a prosecutor's office?
Your Honor, she worked in the same office that the prosecutors work in, and that the director of the Medicaid Fraud Control Unit, who's essentially the chief prosecutor, works in. And so their obligation is, once they get these referrals for fraud investigations, they went out, they got the search warrant, they had the police department execute it. They safeguarded the property as they continued their what's a complex financial investigation of Medicaid fraud to determine whether to initiate or whether to charge Ms. Streisman with a crime. And I agree that, at the time that the act took place and at the time of the complaint, there were no criminal charges pending at that time against Ms. Streisman.
What is the limiting principle behind absolute privilege here? I mean, if we adopt your view of this, it seems to me that absolute privilege will extend to anything that remotely touches the prosecutorial function. Am I right or wrong about that?
No, I don't think so. There are things that prosecutors do and that investigators do that, and I think the case law talks about this, that are administrative in nature, and those things won't be covered. I think one of the examples that the court gave was whether to immunize a prosecutor who spoke at a press conference, and the answer to that was no. And so there are certainly limiting principles.
I think of the expanding nature of criminalizing behavior at both the federal and state level. And it seems to me, though, that what you could say without overstating your position too much, you tell me if I have overstated your position too much, anything that touches on an investigative function by any employee of a prosecutor that might lead to prosecution would be immunized.
I only hesitate on the anything part of that statement, but I think that there is certainly a line that can be drawn that allows for a prosecutor in the performance of, or an investigator in the performance of a function in a prosecutor's office that relates, that is directly tied to the criminal process as covered by the immunity, unlike the prosecutor who spoke at the press conference and made statements that a plaintiff alleged was actionable.
I look at RICO actions. I look at vaguely drawn state statutes. I look at, this is one of those things where, if we're talking about investigating something that we've always regarded historically as a crime, maybe it's less of an issue. But now we're talking about white-collar crimes that are essentially accounting mistakes. Sometimes that's the defense anyway. And now suddenly we're immunizing a broad range of conduct. And it strikes me that, we had this discussion about whether Zutz applies here, and I think counsel's probably right. That's more a testimonial privilege case or not. But the reasoning that's in there, in that particular decision, about the dangers of extending official immunity strike me as, when you get to more extreme criminal acts, I realize that's a pejorative way to characterize it, but it's kind of the way I see it. It strikes me that's a matter of some concern here.
Well, Your Honor, respectfully, that's not the factual situation that you have in front of you. And you do have in front of you the search warrant in this case that lays out the factual allegations that supported the search warrant.
So that everything after the search warrant is immunized, or is it everything the investigator does after the search warrant, they're entitled to immunity?
Again, I hesitate to agree because of the word everything, but I think that there are a lot of things that occur after a search warrant that would be immunized.
Well, but that suggests that there are some things that aren't.
Sure.
And on the, at least as I understand the record here, we don't know precisely, because of the stage of the litigation, we don't know precisely what happened.
Sure, we don't, and we have to take what the plaintiff says is true, which is...
They lost it up.
Yeah.
But, did they lose them because somebody walked off with them? Did they lose them or they're not available because somebody spilled, a 5-gallon bucket of coffee on them? I mean, who knows? And, that to me suggests that at best we don't know whether the conduct at issue should be immunized.
But, Your Honor, respectfully, what we do know, and this is drawn directly from their complaint, what we do know is that there is no allegation of any kind of intentional, willful, malicious act with respect to the lost files that would suggest to you that it's anything but a negligent act. And so I think the court can infer, given the failure to plead anything in that regard, that that's how the plaintiff views it as well. But you're right, we don't know the specific circumstances. In fact, as my client, the affidavit that they cite to in their amended complaint suggesting that my client admitted she lost files, a fair reading of that affidavit suggests that that's not even true. And so you're right, there's just not a lot known, but what we do know and what the court accepts as true doesn't suggest that my client, Ms. Morton-Peters, did anything intentional, anything willful. At most, it might be some lost files. And so at the end of the day, this case really is the decision about whether and under what circumstances to apply prosecutorial immunity in connection with a state tort law claim is one for this court to decide, independent of federal law and independent of the federal development of law, which the federal courts have said their prosecutorial immunity law has developed in that unique context of 1983.
Thank you, counsel. Your time has expired. Mr. Flaherty, you have 15 minutes.
I was thinking about a question Justice Strauss asked me the first time I was up here as I was sitting down about whether or not the contours of prosecutorial immunity under Minnesota law should be a little more nuanced than a straightforward application of Brown, which is the initiation and maintenance of prosecution. And my answer remains the same, that I think not, but I believe there's a more malleable way to phrase or articulate that same test, and it's something that my friend across the aisle referred to, which is this idea that unique functions of the prosecutor's office can or should be protected by prosecutorial immunity. That seems to be essentially a reformulation, in my mind at least, of what the existing test is under Brown. If there is a function that, as a historical matter, only prosecutors exercised, then there's a good argument that that function would be protected by prosecutorial immunity. But the maintenance of property seized under a search warrant is not one such function. So even if this unique function test were applied here, the Court of Appeals would still need to be reversed. And I think, candidly, if this unique function test is something the Court is considering, maybe supplemental briefing on that historical question may be helpful. So that's a suggestion here. I'm not arguing for a wholesale adoption of federal law. And, of course, there is a distinction in the law of immunities between state law tort claims and federal law claims under 1983. The argument here, rather, is simply for this Court not to extend Brown, but rather apply it and say that it meant what it says, and that Brown was in line with this Court's precedent of as all forms of immunity do, of asking what conduct is challenged by the litigation, a conduct-focused inquiry, rather than an inquiry that asks who is the person performing the challenged conduct. In our view, the law doesn't need to change at all. Brown was the rule in Minnesota in 1981 and continues to be the rule today, and we're simply asking
the suggestion here is that the conduct was related to the prosecution,
And certainly as a
related to
colloquial,
a prosecution.
yes, certainly as a colloquial matter, the conduct is related to the prosecution, as the conduct would be for any employee who works in a prosecutor's office. So if related to were the test under Brown, then there would be immunity here. But that wasn't the concern that Brown discussed itself.
Well, do we even have enough information to know what the conduct here was?
We do, Your Honor. It was the loss or destruction of records. Now, I suppose we don't know as to whether or not, and discovery would be needed to show whether that was intentional, willful, malicious, negligent, what have you. But right now, as the claim stands, property was seized by the government and the government lost or destroyed it. Those are the relevant facts. And so the question under Brown is that destruction of property after the seizure under search warrant, is that...
Well, it strikes me that if those are the only two facts, property was seized and lost, the fact that it was seized pursuant to a warrant at least suggested it was intimately related to a prosecution.
And again, I think that is correct because,
And doesn't that end the discussion?
It doesn't
even under Brown.
It certainly doesn't end the discussion under Brown because Brown doesn't hold that any decisions made by the prosecutors within the context of judicial proceedings or before judicial proceedings. Brown didn't hold those are all protected. Brown said the discretionary decision whether to charge and whether to maintain charges are protected. So what is clear on this record is that this loss or destruction occurred before charges were brought or maintained. So prosecutorial immunity shouldn't enter the inquiry at all because we're in that stage long before, I should say, that discretion would be exercised by a prosecutor. And the party here...
And, counsel, isn't it true that prosecutors may be intimately involved in the preparation of a warrant application, or it may just be the investigator going to a judge asking for a warrant? The fact that there's a warrant doesn't necessarily indicate prosecutorial involvement, does it?
You're absolutely correct, Your Honor. Prosecutors don't have to be involved for the procurement of warrants, but even if a prosecutor were involved, it doesn't mean that wrongdoing in connection with the procurement or execution of a search warrant is necessarily part and parcel of initiating or maintaining prosecutions. Sometimes search warrants are executed legitimately and lawfully that don't lead to any further prosecution. In Brown, when this court was characterizing Imbler, it recognized the hardship that citizens bear when they're not when their property is seized, but when the government commits torts against its citizens, and that was a concern of Congress in enacting 1983. State courts were unable or unwilling to police the illegal actions of state officials, and that's why we have federal law. This court wrote in characterizing Imbler that in applying absolute immunity, it's referring to Imbler, it was called upon to choose between the lesser of two evils. It recognized that when this type of immunity is applied, the plaintiff has no redress for their wrongs.
If we conclude that absolute immunity isn't available, is there some other lesser prosecutorial immunity available?
Not prosecutorial, no. Official immunity remains alive and well in this case, and there's a vigorous dispute between the parties on whether or not that applies. And from my read of respondent's brief in this court, I expect that when the case returns to the district court, they would probably move for leave to amend to assert a claim for some new form of quasi-judicial immunity that hasn't yet been recognized under Minnesota law. And, of course, the question of what that immunity is and what it should look like is outside the scope of review on this appeal. But it would not surprise me if they raised that argument.
So with respect to prosecutorial immunity, it's either absolute immunity or no immunity?
Correct, with respect to prosecutorial immunity. And that's one of the key distinctions between prosecutorial immunity and official immunity is a plaintiff can overcome official immunity even if the conduct challenged is discretionary, where the plaintiff can show actual malice or willful violation of a known right. But prosecutorial immunity is absolute. Even if a plaintiff could show that a prosecutor willfully and maliciously, intentionally instituted charges against the plaintiff, that would not and could not overcome prosecutorial immunity. It could, of course, overcome official immunity.
What was the basis for the ruling below that statutory immunity didn't apply?
To be honest, Your Honor, I don't recall at this moment.
Because if there was an assertion of discretionary statutory immunity and that was rejected on the merits,
Yes.
that sort of perhaps suggests the outcome on the official immunity question as well. Perhaps.
Perhaps. On the other hand, Morton Peters appealed the official immunity decision, and she chose not to appeal the other. So perhaps that reflects her view on the relative merits of those, that one is worth fighting over and one is not. Elwood was a case discussed earlier, and that was not a case that applied absolute immunity. It was an official immunity case, but it addresses explicitly the policy concern advanced by Morton Peters here about the need to protect actions of executive branch officials. There the court wrote, official immunity protects public officials from the fear of personal liability that might deter independent action and impair effective performance. As a general matter, that official immunity has been given to executive branch employees as a longstanding matter, and this court has viewed that as sufficient to protect their conduct. In unusual circumstances, this court will grant absolute immunity, but that's been used sparingly. It was granted in Brown, but it wasn't expanded in Brown beyond the initiation and maintenance of prosecution. And again, investigators in state law are not without further redress from a branch of government that we haven't discussed much today, which is, of course, the legislature. If complex crimes are becoming too difficult to investigate because of investigator liability, the legislature can create a new form of immunity that Morton Peters asked for. And that balance between a citizen's right to redress as well as immunity for government employees, that's something that the legislature can speak on in the future if it wants to, but it hasn't given absolute immunity yet to investigators. And in an important respect, under Brown, investigators are different than prosecutors insofar as there is no tort of malicious investigation. There is a tort of malicious prosecution. That was the claim raised and addressed in Brown, but there isn't an analogous tort for investigators. That will explain why there isn't historical support in Minnesota case law, at least from 1856 onward, from giving absolute immunity to investigators. This is the idea of giving that form of immunity truly is Morton Peters asking for the creation of new judge-made law. And it's not warranted as a historical matter. Obviously, any defendant would like all immunities he or she can get, but the question here really is nothing more than is she entitled to prosecutorial immunity? Whether and what other forms of immunity can be granted can be left to the Court of Appeals and the District Court on remand.
Explain to me why, again, this doesn't constitute the initiation of an investigation or maintenance of a prosecution.
Because the decision, two responses to that, Your Honor. The decision to initiate or maintain prosecution does not belong to the defendant. It belongs to the county attorney or an attorney within the Attorney General's office. Now, the county attorney may ask any number of expert witnesses, investigators on their views, but that decision, that discretionary decision, which is protected under Brown, does not belong to this defendant. And then secondly, the harm complained of here is not uniquely prosecutorial. It's simply the destruction of property. And I've yet to see any case suggesting that the decision to destroy or lose property is part and parcel of initiating or maintaining prosecution. If the court has no further questions, I'll simply conclude by saying what we're asking for is a reaffirmance of Brown, an application of Brown to the facts of this case to reverse the Court of Appeals, and then remand to the Court of Appeals to consider Morton Peters' official immunity defense.
Thank you, counsel. Thanks to both counsel for the help that you provided to the court in this case. This matter is submitted. We'll issue an opinion in due course. We're in recess.